And the floor is yours.
Thank you, and good morning, everyone. Welcome to the January 18th, 2022 Enforcement and Compounding Committee meeting. My name is Maria Serpa, and I'm chairperson of this committee. Before we convene, I would like to remind everyone present that the board is a consumer protection agency charged with administering and enforcing pharmacy law. Where protection of the public is inconsistent with other interests sought to be promoted, the protection of the public shall be paramount. This meeting is being conducted consistent with the provisions of Government Code Section 11133. Participants watching the webcast will only be able to observe the meeting. Anyone interested in participating in the meeting must join the WebEx meeting. Information and instructions are posted on our website. As I facilitate this meeting, I'll announce when we are accepting public comment. I've advised the meeting moderator to allot 2 minutes to each individual providing comments. This approach is necessary to facilitate this meeting and ensure the committee has an opportunity to complete its necessary business. I appreciate everyone's understanding. Before we get started, I'd like the meeting moderator to provide general instructions. Moderator?
Thank you. This is the moderator. And for today's public comment, as Chair Serpa mentioned, we will be using the WebEx question and answer feature, and each speaker will have, I apologize, Maria, did you say 2 minutes or 3 minutes?
2 minutes.
2 minutes is what I thought. 2 minutes to speak. I will be providing a 15-second warning when your time is about to expire. We will be taking comments in the order that they are received. And when time is called for public comment, I will display the slide that's on the screen currently. What you will need to do is locate that Q&A icon on your screen and click on it. When you do so, it will open a text box. In that text box, you can simply type the word comment and submit that to our panelists. When I do call on you for your public comment, I will let you know that I have sent you a request to unmute your microphone. You should receive a pop-up on your end with a button that says unmute me. When you click that button, it will unmute your microphone. You may hear a brief recording from WebEx, so you'll want to pause just a moment to allow that to clear before you start speaking. And with that, I will turn it back over to the chair.
Thank you. I'd like to now take a roll call to establish a quorum. Members, as I call your name, please remember to unmute your line. Jig Patel.
Good morning, I'm here.
Good morning, Jig. Sung Oh.
I'm here.
Good morning, Sung. Ricardo Sanchez. I understand Ricardo will not be joining us this morning. Debbie Veal.
Here.
Good morning, Debbie.
Morning.
With the quorum being established, the committee will now entertain any public comment for items not on the agenda. To facilitate this portion of the meeting, as I previously announced, the meeting moderator will open up the line for individuals to provide public comment. You're not required to identify yourself, but may do so. As we open the lines, I'd like to remind everyone that the committee cannot take action on these items except to decide whether to place an item on a future agenda. Members, following the public comments for this agenda item, I will survey the members to determine if any members have a preference for items being placed on future agenda. Moderator, we're ready for public comment.
Thank you. I've opened the Q&A panel. And again, if you'd like to make a comment on items that are not on today's agenda, please click on that Q&A icon, type comment into the text field, and submit that to our panelists. I'm not seeing any requests. Would you like me to close the panel?
Please do. Thank you.
It is closed.
Okay, our next item on the agenda is the approval of the October 20, 2021 committee meeting minutes. Members, included in attachment 1 is a draft of the meeting minutes. Members, do you have any comments or questions on them? As a part of your comments, I would entertain a motion for approval. Members?
Maria, this is Sung. I can make a motion to approve the.
I'll second it. This is Jig.
Thank you. Let's open for public comment.
This is the moderator. We've again opened the Q&A panel. If you'd like to comment on the motion for these minutes, please click on that Q&A icon, type comment into the text field, and submit that to our panelists.
A quiet morning. Thank you.
It is a quiet morning. You're welcome. I will close it.
With the motion on the floor and no public comment received, I will now take a roll call. Jig Patel,
Yes.
Sung Oh,
Yes.
Debbie Veal,
Yes.
and the chair votes yes. Motion passes. Thank you. I think we need to, there you go. One more. Good. Agenda item 4, discussion and consideration of disciplinary guidelines. Members, I take a big breath here. Members, the meeting materials provide background information, including some relevant provisions of law. As you may recall, at the committee's July 2021 meeting, we requested that staff complete a review and provide recommendations for changes to the disciplinary guidelines. The proposed changes are reflected in the document attachment 2. I'm hopeful that you've had a chance to review this information. The chair's report highlights the types of changes that are being recommended, some of which are being displayed on the slide. Good, the slide is there. So these are just a highlight of the types of changes. Updates to reflect the current version and board information, and includes requirements to disclosure of a respondent's email address. 2, transition to gender inclusive language. 3, updating terms to ensure consistency throughout the document and ensuring consistency with language used in pharmacy law. As an example, the word psychologist is replaced with mental health practitioner. 4, language to provide that any new licenses issued while an individual respondent remains on probation shall be placed on probation under the specified conditions. 5, require a licensee whose license is surrendered to seek reinstatement from the board in lieu of the current process of seeking licensure through reapplication. 6, changes to the categories for some violations. The changes are primarily relating to the scope of practice violations, violations involving sterile compounding of drug preparations, use of policies and procedures that violate pharmacy law, and repeated failure to provide patient consultation. 7, some new optional terms. These are documenting some of the terms that we have used in the past in disciplinary cases. For example, new optional term 41, individual licenses to include requirement to complete board's 1-day training program on prescription drug abuse prevention and pharmacy law. New optional term 43 for individual licenses and term 26 for business licenses include an optional term to establish an administrative fine. New optional term 27 for business licenses to include an optional term establishing a consultant review of business operations. 8, clarifying relevant terms relating to the consultant review, I'll say that over again. Clarifying relevant terms relating to the consultant requirement to explicitly state that the proposed consultant shall have appropriate education, training, and professional experiences. 9, require a release of authorizing a mental health practitioner to share information when such a term is required. 10, including optional language under the posted notice of probation term to specify how such a notice shall be provided. 11, where appropriate, provide specific timeframes within the actions must be taken. For example, clarify the necessary reporting requirement for notification of departure. I appreciate the work undertaken by staff and council and agree with the recommended changes. This has been a considerable effort by many people. So hopefully not to make things confusing, I do agree with the changes, but I do have one suggestion that on page 18, that we expand the potential restriction on supervision and oversight. You will note that example refers to the language of designated individuals responsible for compounding, and it refers primarily to USP 797. I would like to, as a part of our discussion in motion, allow myself and staff to update that a little bit to not just limit it to USP 797, but to include all USP sections referring to designated individuals responsible for compounding. Members, I would welcome your comments on the changes and would entertain any motion if you believe a motion is appropriate with this minor change that I mentioned.
Hi,
Hey,
Maria.
Maria, I finally found page 18. Because I was going 18 in the materials. So what, can you just kind of go over that again, what you're
Sure.
proposing to do?
You notice that there's a term in there that refers to potential restrictions on supervision and oversight.
So is it under 7, 8, option 1? I'm looking at page 18. What?
Okay. Real quick. I just have my notes here.
Sorry.
No, that's fine. You're correct. I should have pulled it out. Option 2?
Option 2, okay.
I believe option 2. Yes, option 2. The change adds a new area for potential supervision that could be added to terms, and that is the term designated individual. We're familiar with the terms pharmacist in charge, designated representative in charge, and responsible manager. But the term designated individual is something that is newer to us, and it's defined in USP language. The information that's here was limiting it to as defined in USP 797, and that's referring to sterile products. So I'd like to change the language a little bit to say referring to a USP, all USP sections referring to compounding, and so it's a little bit more broad so that we could talk about all the other areas of compounding and not just limit it to sterile products. That makes sense?
Yeah, okay.
Maria, I support that, and I'm not sure how to go on about it. I do have quite a few that I wanted to just bring to everyone's attention to get everyone's thoughts.
Okay.
Should I just do one by one, or?
Sure,
Yeah.
go ahead.
Let's talk.
So first one, I wanted to ask what everyone's thoughts are is the terms of probation under individual and physical licenses. I'm
sorry, so on what page are we on?
Page 5.
Thank you.
The first
Okay, wait a minute, Song, give us a chance to get there.
Oh, sorry. So page 5 in the order in the disciplinary guideline, not page 5 in the PDF.
Got it.
So we have terms of probation. It starts a sentence with a minimum 3-year probation period has been established by the board as appropriate. In most cases where probation is imposed, minimum 5-year probation period has been established by the board as appropriate in cases involving self-administration or diversion of controlled substances or dangerous drugs and or dangerous devices or abuse use of alcohol. I'm just curious, where are we establishing this? Because I don't recall we having some policy statement or, I'm not really sure where this is coming from. It's been there forever, but I don't think it's really necessary for it to be there. Are we? Because as far as I can recall, we are really flexible in our probation.
So I guess before we ask the staff to actually specifically talk about where this comes from, you have to keep in mind that the disciplinary guidelines are used by judges and those that are reviewing disciplinary cases. And this comment is often quoted in the judge's response during disciplinary presentations. So I know that they use this statement quite a bit. And it is very old. I'm not sure how long it's been in the disciplinary guidelines. Perhaps someone from the staff or Eileen would like to comment on the purpose of it being here and how it's used.
This is Anne. I can jump in if that's helpful. I'd have to do research to see how long that has been in, but it is existing language. But the guidelines are just that. They are guidelines that are setting out kind of the board's policy. And it is intended that it's the board's policy, and it is intended for all those that are using the guidelines either for settlement or for reaching a proposed decision. So it's kind of where you're speaking to here, it's kind of laying out some of the basic policy. And then as you go through the guidelines, you'll see where additional clarity is provided in some of those.
Okay. So that exactly, that's why I kind of feel like it's, I don't know, it just seems to add a layer of more confusion in my opinion, but if everyone feels that its places for sure need to be there, I'm okay. So just curious what your thoughts are on that.
Do you want to say discuss as you go through each one of your comments here, Song?
Or do you want me to go down the whole thing? Yeah, I was gonna just, because I have
It sounds like it's quite a few. So let's do them, let's discuss them as the board one at a time. And then when public comment, if they wanted to add anything for public comment, they could. But go ahead, Debbie. It sounds like maybe you have a comment about Sung's question.
I guess I'm comfortable with it, and maybe it's because I've been around a long time and I've just been there the whole time. But it seems like, in fairness, you need to kind of establish, what are the probation minimums in certain situations. So I feel like it's fair. In fairness, we need to have that statement in here.
Okay. So then just going on to category one. So I'm moving on to the second one. So category one, it says revocation state, page 6.
Page 6, thank you.
2 years probation minimum. So I just find it to be a little bit interesting. Like we start out saying minimum 3 years in general is established. Then we go to category one and we say minimum 2 years probation. I just think that it's a little bit inconsistent. I want us to give ourselves a little bit more flexibility. But that's just my thinking. I think that there should be not so much of these, and I understand that this is not it. This is not always 2 years. We always have room to change to however, but if this goes to, proposed cases where judges are looking at this, I feel like this is causing it to be more inflexible. Looking at their mitigating circumstances, people have a lot of those backgrounds. And as long as this doesn't, give judges and us flexibility, I'm okay. But I've always felt that these things just being in there kind of makes it more rigid. And I understand too, you, Debbie, there should be some minimum, right? But at least we should make it consistent is how I feel.
So now I kind of understand where you're going with your first statement. Your first statement, you're saying on page 5, when we start probation, you're saying maybe we don't need to have those first 2 sentences because as you go into each category,
right,
it defines it.
Exactly. That's, yeah. I just kind of feel like there's
I get it. I would kind of, Eileen, do you have an opinion on that?
I think that you still have flexibility under both. I think Dr. Serper or somebody had said, I think sometimes these statements are used really by ALJs when they're trying to make decisions. I think it might lead to some more consistency versus, decisions all over the map where the board may decide to exercise its discretion. But I still think the board's got discretion and the ALJs do with the different categories as well. But that's kind of up to the board to determine. But I think it does add some helpful guidance to ALJs who may be hearing a proposed case, and also for some of the people who are maybe trying to negotiate settlements where some of the settlements or the stipulated judgments might come out. So those are my thoughts, but I think you do have flexibility in all the categories when, because even with that statement, they say in most cases, not all cases.
Mhm. And I think referring to page 3, which talks about the determination of penalties, it says determining whether. So, your point is a good one about it being repetitive, and I hear you saying that. So, I'd like to hear more about that. But I still would like to keep some of the detail because I think we do have a lot of flexibility, and the judges have a lot of flexibility. When you look at page 3, that's all about determining whether to follow the guideline or whether there is evidence to make it more severe or to mitigate aggravating evidence.
Right.
That's the
Yeah.
word they use.
I just,
But
we
your point
always
is a good
think
one.
we always talk about how trying to keep it consistent. And as always, we all know that not all cases are the same. Every case is different.
Mhm.
But I just think that we're starting off. We have one sentence here saying minimum of 3 in general, in most cases, that's all, most cases. And then we have category 1 violation, it's minimum is 2 years probation. So I just kind of feel like we're setting up ourselves for inconsistency to begin with. It just doesn't, if anything, we should say maybe 2 years in the first sentence. So I just, think.
You almost can't do that, because then look at category. There was one that was like 90 days or something. Oh,
Yeah.
that's
Can I jump in for just a second?
Yeah, that's
Go ahead,
revocation.
Ann.
Okay. Who's trying to jump in?
So this is Anne. If I can
Thank
just say something just really fast. So on page 5, you're really kind of setting the table, right? So this is in general, it's probably going to be, generally it's going to be about 3 years. And then as you go down to the different categories, then you're really kind of drilling down into these are the types of violations where this is what it is. So we're kind of like setting the table at the front end. That's where we're talking about rehabilitation, mitigation, everything, right? So we're setting the table at the beginning, and then we're starting to narrow and drill down. So I think that's, I'm just providing context should it be helpful in your decision making.
Okay. Yeah, no, that's good. And I think that kind of helps me feel a little comfortable. So go ahead, Jake. Sorry.
I agree with Sung. I think if we open up on page 5 by stating a minimum 2-year probation, because in category 1, that's the minimum, and that's fair to state that. And that will set everything up. And then we are elaborating on the both categories, and that further sheds light on each who gets what. So changing just the first sentence from 3, a minimum 2-year probation period, and that would make it uniform.
Well, the thing, just to jump in, is I'm not quite sure what that first sentence is talking about, because it says appropriate in most cases. So then that would mean we'd have to determine what is most. So perhaps just taking trying to be a happy medium and speaking just off the top of my head, what would be your thoughts of, C category sections below for minimum probationary periods established by the board?
Right.
Period.
Yeah, that's kind of like how I look at it. I just don't want to put years. I mean, again, I'm not a big fan of, as you all know, just putting arbitrary years and stuff. And so,
but I think I think that it's, what does that sentence mean? And I think it's because it's most, not as the minimum is 2 years, because it's the most. And so, maybe most of our violations are in category 2, and that's why that came from. So now we're not even looking at what is the most. So Anne and Eileen, would changing those first 2 sentences to be more general, not to cause any.
Matt, I recommend. How would you feel about removing the first 2 sentences? And so it would start with terms and conditions are imposed to provide consumer protection.
That's what I wanted to propose, but.
So is the rest of that language, especially under the 5-year, is listed under category 2 and 3? So we're not taking something out that's not listed elsewhere?
Yeah, I believe that it's there as part of those categories.
Okay. So, well, we can continue, Sung, and then you can make one big
Okay.
motion at the end. How's that?
Well, something to marinate and think about. So I'm not like, again, I'm all for discussion. I'm not like being very strong, feelings about any of them, but it's just something that I think we're trying to make it more consistent. So another one is we're now adding public reproval language under page 13. So I'm just curious, are we able to impose administrative fine if we are giving public reproval? It is on PDF 37.
So that's page 13 of the disciplinary guidelines, public reproval.
Yeah, may I jump in? I apologize,
Yes, go
Maria.
ahead.
Sorry.
No,
Yeah, we're clarifying the language of the public reproval. So the underscored is the new language. So we're just kind of clarifying. But yes, Sung, as part of a public reproval, you can add an administrative fine if the board thought that was appropriate.
Okay, and we don't need to have that into our disciplinary guidelines for us to be able to propose administrative fine, right?
I think that's in another section that all levels of discipline are qualify potentially for a fine. Anne or Eileen, that's my interpretation.
Sorry, I was having a hard time getting off of mute. So the administrative fine piece, as well as several of the other terms, right? I think you could do a public reproval and then require someone to also take the ethics course, for example, or, the prescription drug abuse prevention training. So the guidelines are detailing out the buffet of options, if you will. I'm not sure that that's the most elegant way to say it, but hopefully conveying kind of in general.
The reason why I brought it up because we're adding optional conditions 43 administrative fine. So I was wondering if that means that we need to add administrative fine under public reproval as well. But if we can, that's good. I'm happy to hear that. I'm hoping that's good. Moving on. I'm hoping that I'm not missing something about 41 condition. It's page 15. Tolling of suspension is crossed out with replacing with board's one-day program. What's going on with the tolling? Are we assume that if they are not following the probation, we just assume they're going to be told? Is that what's going on?
I would need to confirm, Sung, but I believe that was a numbering error. And so we were taking advantage of that numbering error and putting the one-day training program in, addressing a clerical issue through adding the one-day training program.
I believe the tolling is under standard conditions, and that would be under 14.
Okay, so it's already in there. Okay, perfect.
But that's a good catch. I didn't even see that one. Thank you, Sung.
And then under page 22, optional conditions 19, pharmacist examination. We decided to do within 6 months, but if we are giving the pharmacist examination as a precedent for their licenses being reinstated, we are giving them 12 months. So should we just leave it blank or I don't know why 6 months.
Well, these are guidelines that with the vast majority, and I think recently we've had situations where they were not, I would say, normal situations. And so that's why we customized the term. But this would be the standard term for somebody who would be receiving term 19. And maybe Anne or Eileen could speak to that also.
Yeah, but I would have to speak. Just Anne, before you speak, I have to agree. I feel like a lot of times we give them a year, don't we?
Well, keep in mind that this standard term is that they pass within 6 months. So they're practicing during those 6 months. The situations that we gave them a year to pass before they start practicing. So that's not a standard term. That was a non-standard term. So I would feel really uncomfortable giving someone a year to practice and to pass the test, because that's another year of their not passing the test, but they're still out there practicing. Whereas
no, wait, they can't practice if they haven't passed, have they? Can they?
You look at the term, I think this term is telling them that they shall pass within the next 6 months. It's not exactly the way that we have been addressed the term in those few cases that we've talked about in the last year.
Well, it says respondents shall not resume the practice of pharmacy until they take and pass the examinations.
I'm sorry, may I jump in for just a minute?
Yeah, please.
This is Anne again. So there you have standard language for reinstatement. In that you have granted by the disciplinary guidelines a year, as I understand it, for someone that is taking the exam that already has a license. The disciplinary guidelines establish 6 months. So there's a difference in the board's policy when it's a reinstatement versus as a term and condition of probation.
And also keep in mind, for anything for reinstatement, they need to pass both exams before the license is reinstated. So I view 19 as kind of an optional condition you can impose on a pharmacist where you don't revoke their license. The 1 year period to reinstate gives them 1 year, but they can't practice. Their license won't get reinstated until they pass both exams.
So thank you for the correction. So that I misstated my statement previously. So I think it was Anne who stated that term 19 is about discipline, which is 6 months. And what you're referring to 12 months was regarding reinstatement, which is not discipline. It's a different process.
Okay. Okay.
That was a really good question. Very good. And I didn't know that either. Thank you, Anne, Eileen, and Sung.
Wait a minute. I'm not totally clear on this. I apologize if I'm dense. But so 19 is I'm trying to go back up here. So 19 is under optional conditions of probation. And so what number is it that they've had their license?
So this document is not for reinstatement. This document is all about discipline, not for reinstatement. We don't use these guidelines for
no, there is a part about reinstatement, I think, under page.
Yeah, I think like page, let me get to it. 13? I think it's page 13 where license reinstatement with conditions and option pharmacist only. Petitioner must satisfy licensure requirements as defined within 1 year of the effective date of this order. Failure to take and pass the exam within 1 year.
I'm scrolling. Just give me a sec. I'm trying to find page 13. Okay, license reinstatement. See, this is page 14 where it says license reinstatement. Oh no, it's back up here, 13. Okay, petitioner.
You are correct. This is a very complex document, so I appreciate us going through it in detail.
Okay, so let me just kind of say this. So if they've gone through revocation, then option. So then what's on 13, pharmacist only A, within 1 year. So say that again. When would the option on page 13 be used versus the optional? So this is, you have to take and pass within a year versus the other one says take and pass within 6 months. I know you said this, Ann, but can you just say it again, maybe slower? I don't know why. I'm just being dense here.
I'm going to give it a whirl. Okay. So when someone's license is revoked, surrendered, whatever, right, permanently removed, their process for reinstatement of the license. So if someone wants to wants to, reinstate their pharmacist license, the term that is displayed on the slide right now talks about the steps that that individual must take to reinstate the license. So in this case, specific to the exam, they have 1 year from the decision to take and pass the exam. And that is a precondition of licensure, right? So before they will get issued the license, they have 1 year to take and pass the exam. Now, I think that the policy argument for a year here versus 6 months in the other there's several of them, but one argument for a longer period of time here would be that the individual may require additional time to prepare to take those exams. When we go to the other term, I'm sorry, Shelley, that I'm giving you a workout here.
Before you go there, I have a question. Before you go there, before Shelley has to move. So looking at this, it says license reinstatement with conditions. So it says hereby order that the petition for reinstatement is granted upon satisfaction of the following conditions. So if we've revoked their license, and this says this is optional, so not in all, like if their license has been taken away, I don't understand how this could be optional. Maybe the NAPLEX part could be optional, but the CPJE can't be optional, right?
So what this is doing here, Debbie, is it saying when it's a pharmacist, you're using this language. When it's a tech, you're using this language.
Okay, so option, I see. So the option is pharmacist tech. Okay, thank you. Okay.
So then when we look here, this, as Maria indicated, is someone that continues to maintain their pharmacist license, right? So that they still have their license, is being disciplined. And one of the terms and conditions of that period of probation is taking the pharmacist exam. And that's where you have established that they have 6 months with which to do that, right? So this, again, it's a guideline, but the individual could very well be practicing during this entire 6 months. It would depend on other terms and conditions of probation, but this term in itself allows for 6 months to take and pass the exam. So I hope that was clarifying. I'm sorry if I just made it worse.
No, you made it better.
I think we just rarely see that. That's probably why I was also confused myself on that. Anyway, I'm almost there. I'm sorry.
No, you're fine. You're fine.
We have some time today. So next is it's kind of under categories. I'm at page 42. That's now going on to the premises terms of probations and looking at what are the offenses. And I was just wondering what everyone's thoughts are. I was trying to piece together if any of the violations speaks to any delaying patient care, and I could not find it. So if there is, please point to me. And if there is not, I wanted to get everyone's thoughts are on maybe adding that as a category 1 or 2 violation of causing delay in patient care, or violations involving delaying patient care, providing delaying patient care.
Could you give an example of where a violation delayed patient care?
Yeah, like pharmacy might have received a prescription, but instead of them checking in or with the patient, they just would file a prescription for antibiotic prescription, and it goes by 3, 4, 5 days, and they haven't received the medication, so they aren't able to start the medication. I mean, granted, obviously, it will depend on the situation, so I don't want to make it so specific. Obviously, and it would be concerning if there is a situation where a patient refuses to take the medication. That's not our responsibility, but obviously investigation would determine. I think it's only when delaying patient care cause potential harm that was obvious oversight on the pharmacy's part. So that's kind of what I'm thinking. Maybe it's a citation. I'm not sure, but
Yeah, well, I'm not sure that in our regs, we make it the responsibility of the pharmacist to track down the patient, let them know, in the case of your antibiotic, and let them know, hey, we've got an antibiotic prescription on file here, please come pick it up. I don't think that's one of our regulations, so I feel like,
or like mail order pharmacies, it gets delayed and patients are not able to get their medication for like 2 weeks. We hear that all the time. I just thought, those
Yeah.
maybe, but
So, Sung, what do you think? Oh, go ahead.
There's one thing I was going to say, President O, is maybe those type of situations would be covered in basically the factors that everyone determines actual or potential harm to the public.
Okay.
Instead of find something like that out. So that's also an option times when we look at which penalty we're going to impose, be it the board or an ALJ, you look at the potential harm to consumers.
Okay.
Thank you, Eileen.
All right. That explains. And then one last, I'm almost there. So under category 2, we have one of the terms under page 43. One of the things is gross immorality, incompetence, gross negligence, and clearly excessive furnishing of controlled substances. I feel like clearly excessive furnishing of controlled substances fall under corresponding responsibility, which is under 3. So I don't know if there was a purpose for that sentence being in there. I'm being a little nitpicky here, but I felt like that's redundant. But again, if it gives flexibility, I'm okay leaving it there.
This is Anne. I do think that it gives some flexibility. I think that this is at the pharmacy level as opposed to at the pharmacist level, which is potentially why it's at both. This is existing law or existing language. So I'd have to go back and research how it landed here, how it landed in that.
Okay. In that case, shouldn't that be category 3 or?
Well, I think Anne also pointed out that there's a difference between the discipline of a respondent versus the discipline of a business.
Mm-hmm.
And so that may be why it's in both, such that it provides flexibility.
Okay, that's it. I'm sorry that I had a lot. Just wanted to make
very
sure
good.
This is a very important document, as all of us know. So I wanted to make sure that we look at some details.
I appreciate that. So, Debbie or Jig, did you have any additional comments before we go to a motion and then public comment?
Jig, do you have anything? I actually do, but I'm trying to find it now.
I don't have anything more.
Okay, sorry. Let me see if I can find. I did have a question. Just give me one sec. Okay, my question was on page 12, surrender. It says respondent surrenders, and it says respondent understands and agrees for the purposes of BMP Code 4307. This surrender shall be construed the same as a revocation. So, is that because this is the disciplinary guidelines, this surrender is different than other surrenders. Is that like if someone just decides not to renew their license because they're old, and they do that at the time of renewal, and you check the box or whatever to surrender your license. I just want to make sure that this surrender, because it's discipline, it's revocation, but someone could surrender their license and it's not revocation.
What's the term on the license that when a person decides to no longer practice and they're not in any discipline? I don't think it's surrender. Is there a different word?
I thought they show as canceled.
Yeah,
Or
canceled or
retired.
retired, depending
Retired.
on
So
the
Debbie-
avenue that they
Okay.
pursue.
So
So-
surrender is a verb
A
that would
discipline.
only be used in discipline. And if you're not being disciplined, you're either canceling or retiring your license.
Yes.
Okay. All right. Thank you.
Good question, Debbie. As we get closer to retirement age, I don't want to get stuck in there too someday.
Well, yeah, someone I think is closer than you to retirement age, the person who happens to be speaking. And so at that time, I don't want it to be construed as revocation. Okay, very good.
Okay, Sung, Jig, or Debbie, any other comments or questions?
I can try to take a motion.
So maybe if we'll project the motion and just make the little adjustments to the motion, Sung, based on our discussion.
Sure.
Can you see the
right.
projected?
I will
Does the
do my
projected
best.
include the change you proposed, Maria?
No.
So we need to add in your change also.
And Anne, would it be sufficient to say to include the to give the executive officer and the chair the authority to make changes as discussed in those two sections? Or
Well,
I
why
think
don't I
that
try
would be,
Go ahead, Anne. Yeah.
yeah, I think that would be sufficient. Or you can specifically call out the two sections. I think that there's general agreement, but perhaps Maria, you could just summarize what the changes are, ensure that the committee is in agreement, and then, as determined by the committee or something like that.
Go ahead, Maria. Just confirm those changes.
so of course I've marked the pages, but I didn't mark them so that they come up. So let's see, the first change is on page, did you write down, does somebody have the two pages?
If it's helpful, page 5.
Thank you. So the first change that we would give to the EO and myself would be to adjust the paragraph on page 5 regarding minimum probationary period to meet our discussion. And the second was to adjust paragraph under option 2, page 18, that refers to USP 797 to include all USP chapters referring to compounding, and to adjust the wording to accomplish that. Just those two areas. Is that correct when I heard from the discussion from the board members?
I believe so. Yep.
So Anne and Eileen, what's the best way to do that motion?
Can Maria make the motion?
Yeah,
Well,
go ahead, Maria.
No, Sung's about to do it. Go ahead.
Recommend initiation of rulemaking to amend CCR section 1760 and the disciplinary guidelines incorporated by reference as presented, with addition of striking out first paragraph in page 5 regarding minimum probation terms.
Not
as
the whole
well
paragraph.
as
Not the whole paragraph, though. It's just the first two
sentence.
sections.
First two sentence in both terms of probation for individual licenses and premises, and changing page
18.
18 under optional terms to strike out 797 and to include all USP chapter as presented, and authorize the executive officer to make any non-substantive changes along with chair to changes prior to initiation of the rulemaking. Further, if no adverse comments are received during the 45-day comment period and no hearing is requested, authorize the executive officer to take all steps necessary to complete the rulemaking and adopt the proposed regulation in section 1760 as presented.
I'll second
That's
that.
clear. Thank you.
Great. Having had discussion by the members and a motion and a second, I think we're ready for public comment.
This is the moderator. I've opened the Q&A panel. If you'd like to comment on the motion before us, please click on the Q&A icon on the screen, type comment into the text field, and submit that to our panelists.
I'm expecting a lot of discussion here, so let's give it a moment.
All right, our first comment comes from Joe. Joe, I've sent a request to unmute your microphone. Joe, you should see a pop-up at your end. You'll need to click the unmute me button. There you go.
Hello?
We can hear you.
Okay, good. If you take a look at category 1, it says you're going to get a revocation and 2 years probation for violations of record keeping requirements, smaller, isolated failures to enforce prescriptions or refills. I mean, a lot of these things seem minor or can be dealt with fines or just simply observations and corrections. Why do you got to get your license revoked? Stay on probation for 2 years. And take a look at specifically compounding. Any compounding, any improper compounding, you know how many laws and requirements that we have to follow? I mean, there's corrections all the time. FDA gives you corrections. Board of Pharmacy should give you corrections. But if they find any improper compounding that maybe a technician did, maybe they didn't put the contact solutions down long enough, that means the pharmacist in charge is getting their license revoked, stayed on probation, severe damage to their reputation, and most likely may shut down that pharmacy because probation, you're automatically kicked out of insurances such as Medi-Cal. And then you got to put up these big signs that says this pharmacy is under probation. Nobody will want to even go to your pharmacy. And there's nothing here that's that serious that you need to revoke their license for. So you really need to take a look at category 1. This seems way too harsh. The other problem that you have here, which you have 4 sections here of disciplinary action, but there's a 5th one, and that's called the letter of reprimand. That should be up here. Okay, maybe that should be one above this. And it's
Uh-oh, did we lose him? Moderator? I'm
reprimand.
sorry, Mr. Grisella, we lost you for a moment. Can you back up and give like the last 15 seconds again?
The other thing that's missing is the letter of reprimand. That is a disciplinary action. It is not listed up here, and that should be used more often than these revocations. Your cases will go rapidly, and if it does go in front of a judge, they'll at least see there's an observation here that you can use a letter of reprimand. I'm going to tell you, revocation and probation is very bad. This should be saved for the dangerous people, not just these common type violations, which fines can take care of. So I really think you need to take a look at this a lot closer. And because like I said, this probation is severe damage to the pharmacy. Many of them are forced to shut down. Many of these are small business people that their life savings is in this.
Time has expired.
So anyways, please take a look at the letter of reprimand specifically. That needs to be used much more.
Thank you. And I think just to assist the members of the public to understand, I typically do not comment on an individual's comment, but the disciplinary guidelines we're looking at today are for items of discipline and for issues that rise to the level of discipline. So those issues that don't rise to the level of discipline sometimes get a warning, get an inspection, and get citations and fines, which includes the other types of letters. So again, this document is for those situations that rise to the level of discipline because of public safety. I think that's all I want to say, but I just wanted to clarify that for members of the public so that we don't get caught into talking about citation and fines also, which is a whole nother level. Thank you.
Our next comment comes from Danny Martinez. Danny, I've sent a request to unmute your microphone.
Can you hear me?
We can.
Okay, thanks. Danny Martinez with the California Pharmacists Association. Good morning, board members. So generally, I don't have a lot to say in terms of the changes. What I would ask the committee to consider as the board itself begins the standard of care ad hoc committee meeting starting March 9th, to take into account whether these changes to the disciplinary guidelines are consistent with possibly instituting a standard of care form of governance of pharmacy as opposed to the current enforcement model that we have. The other thing I would also just point out, and again, I'm not asking for any changes, but we've heard in the past, members of the public and the board itself has heard concerns about, uneven distribution of discipline depending on where you are in the state from inspectors. So that should be something that should be taken into account during these guidelines. Is that the board wants to make sure that the inspectors are applying discipline evenly and correctly and consistently. I think the consistency has probably been the biggest concern over the last few years, where you will hear pharmacists who are being disciplined very differently for the same issues in some of the same cases. And we're not sure why it's less serious now or more serious then or to that effect. So just wanted to make those quick comments. Thank you.
Thank you, Mr. Martinez.
And seeing no other requests, would you like me to close the panel?
Please do. Thank you.
It is closed.
With a motion on the floor and public comment received, I will now take a roll call vote. Let me pause for a moment. Any other member comment based on public comment, or are we ready for the vote? Hearing none, we'll go ahead for the roll call vote. Jig Patel?
Yes.
Sung Oh?
Yes.
Debbie Veal?
Yes.
And the chair votes yes. Motion passes. Thank you. Okay, next item on the agenda is item number 5. Discussion and consideration of frequently asked questions developed to discuss requirements for outsourcing facilities providing patient-specific prescriptions. Members, as you recall, as a part of our October 2021 meeting, we discussed implementation of several provisions contained in Assembly Bill 1533, including provisions to allow for California licensed outsourcing facilities to dispense patient-specific prescriptions. As a part of that discussion, we noted the need to develop educational materials to assist entities with understanding the relevant provisions of pharmacy law. I draw your attention to attachment 3. This includes a copy of the draft FAQs. Members, I have reviewed the FAQs and believe they are appropriate. I would appreciate your thoughts on the draft. And if you believe they are appropriate also, I would entertain a motion to recommend approval. Members, any comments or questions?
I can make a motion, Maria, to approve the FAQ. I don't have much comments on FAQ. I think it's well written, and we do as good as we can to try to guide them in how they can practice to dispense prescriptions.
Thank you. Do you have a second? Or any other comments?
I'll second. Debbie.
Thank you. With the motion on the floor, moderator, let's open the lines for public comment.
This is the moderator. We've again opened the Q&A panel. If you'd like to comment on this item, please use that Q&A icon to open the text box. Text comment into that field and submit that to our panelists. Our first comment comes from Stephen Gray. Stephen, I've sent a request to unmute your microphone.
Hear me, please?
I'm sorry, Dr. Gray, we lost you for a second. Can you start over?
Yes, thank you very much. One of the questions that I don't think is covered in the FAQs, forgive me if it is, but is the question comes up about security of the facility. For an example, if they're filling patient prescriptions, and one of the requirements of a pharmacy is that the facility can only be opened and closed by a pharmacist. In other words, only a pharmacist can have a key to that facility. And in addition to that, there are questions about the separation. In history, there were requirements that the pharmacy part of a facility had to be completely separated from any part of the facility that was doing GMP type compounding, which of course outsourcing facilities do. So I think my comment would be, I think that there needs to be an FAQ addressing that type of information. Thank you.
Thank you, Dr. Gray. And just to remind members of the public, these FAQs are specific to patient-specific prescriptions and not to the licensure category for outsourcing facilities. This is just one function of an outsourcing facility.
And I'm not seeing any other requests for comment. Would you like me to close the panel?
Please do.
It is closed.
Board members, any further discussion based on public comment?
I'm sorry, Maria. I have one question actually for Anne. Sorry to put you on the spot, Anne. Regarding self-assessment, would any outsourcing facilities that are providing individual patient prescriptions, would they need to complete self-assessment that are different or special?
So we do have staff that are working on drafting a self-assessment for outsourcing facilities. It is not complete yet, so it has not been brought to the committee or the board for consideration.
Okay.
Okay. We have a motion on the floor and public comment received. I will now take a roll call vote. Jig Patel?
Yes.
Sung Oh?
Yes.
Debbie Veal?
Yes.
And the chair votes yes. Motion passes. Next item on the agenda is item number 6, discussion and consideration of Senate Bill 311, Compassionate Access to Medical Cannabis Act to Ryan's Law. Members, during our last meeting, we discussed Senate Bill 311. We noted that the measure as amended contains conflicts with the measure itself, as well as conflicts with the stated intent of the measure as it relates to the handling and use of patient-provided medicinal cannabis within a hospital. Since our last discussion on the topic, staff have concerned that the author's office intends to pursue amendments to clarify the intent of the measure as included in the letter to the Senate Journal. Members, a copy of this letter is an attachment 4. I note that this issue on this legislation goes well beyond the board's jurisdiction. While I understand the concerns of patients and the licensed public, and that there is a need for additional information on the measure, there appears to be no action appropriate for our board. The board continues to advocate for education on the proper and safe use of medications and encourages individuals and organizations to continue to provide ongoing education on these types of topics. If there are specific legislative concerns, I would suggest that this be discussed with the author's office and, if needed, brought to the attention of the Legislation and Regulation Committee for consideration. It's a very complex topic, but it seems that we have limited scope in this area. So members, I welcome your comments.
Maria, I agree with your comments.
Thank you, Debbie. Any other comments from the members? Hearing none, I think we're ready for public comment.
This is the moderator. I've opened that Q&A panel. If you'd like to comment on this item, please use that Q&A feature to submit your request by typing comment into that text box. And our first comment comes from Danny Martinez. Danny, I've sent a request to unmute your microphone.
Yes, thank you. So I'm going to slightly disagree with you, Madam Chair, in the sense that as I understand the bill requires that the storage of the medical cannabis to be stored in the safest part of the hospital or the most secure part of the hospital. Depending on the hospital, some of them may choose to actually use the pharmacy because it's the most secure portion of the hospital in order to store these conditions. So in those cases where the hospital makes that choice, I believe that the Board of Pharmacy now comes into play, and this is where the licensees have an issue, because if the hospital is telling them we're going to store this medical cannabis in the pharmacy, as has been pointed out by several of the advocates, that is not possible, or that it puts them in a place where they're being subjected to possible discipline by the board or by the FDA under the letter of the law. Now, the board may choose not to, and that's fine. The FDA may choose not to, and that's fine. But in terms of where your jurisdiction might lie and why the Enforcement and Compounding Committee should have, at the very least, I believe there should be some sort of FAQ on what needs to happen if the hospital chooses to store this in the pharmacy. Guidance from the board would probably be most appreciated by the pharmacist working in the inpatient setting. And then, to the extent that you can, to where the board's laws allow you to. And that guidance will at least alleviate some of the concern coming from pharmacists. It won't alleviate all of it because there's the FDA to deal with. And then, we'll see what the author intends to do this year with his legislation. But I believe that this committee should at least look into possibly creating some FAQs or creating some sort of guidance document should the hospital choose to store this in the pharmacy. Thank you.
Thank you, Mr. Martinez. I would suggest you read the author's letter to the Senate Journal, and I think that may address your issue.
And our next comment comes from Cody Peterson. Cody, I've sent a request to unmute your microphone.
My name is Cody Peterson. I'm a pharmacist at Children's Hospital Orange County. I'm calling in regarding SB 311. As I hear the board say they really don't have jurisdiction in this space, I just wanted to reinforce that I think it's really important that we reassure pharmacists that by complying with SB 311, they are protected underneath state law. And to be honest, I'm not sure what forum or how this subcommittee could contribute to trying to set forth that understanding. But pharmacists should know that if they're, complying within SB 311, that they're not at risk of losing their license simply by, let's say, for example, like Mr. Martinez just said, handling cannabis within the policies of the hospital. And it would be really great if we could reassure pharmacists so that they can facilitate what's necessary, which is, again, safe and appropriate medication administration, which the state has decided this is. So my name is Cody, I represent the PCCC, and thank you.
Thank you, Dr. Peterson.
Our next comment comes from Lori Hensick. Lori, I've sent a request to unmute your microphone.
Hi, good morning. I'm hoping everyone can hear me. Can you guys hear me okay?
We can.
Okay, great. Thank you. So, hi, my name is Lori Hensick. I'm a pharmacist and I'm representing Scripps Health. I too want to echo Danny Martinez's comment to just request that the board reconsider their statement about the fact that this falling out of scope. As the entity that licenses both pharmacies and individual pharmacists that would be involved in the process of using medicinal cannabis, we're looking to you because, also the entity that issues enforcement action against those licensees. And so in addition to the concerns that Mr. Martinez from CPHA had mentioned, I wanted to add that in the inpatient space, orders for continuing outpatient therapy, which is truly the intent of this legislation, is to continue some therapy so that the patient can remain comfortable. Those orders are may, in some cases, be reviewed by pharmacists. And so as those orders come through for continuation of therapy, if a hospital were to choose that route whereby a pharmacist were to review that order to help with the processing, that would then fall under presumably the board's jurisdiction in terms of enforcement to make sure that the pharmacist is doing things, is verifying orders properly under the pharmacist scope of practice, which is enforced by the Board of Pharmacy. And so I would just ask the committee and the chair, Madam Chairman, if you could reconsider that position, because very much so we're looking to the board to just really clarify the board's stance. It's very clear that the letter to the Journal from, I worked directly with Senator Wayso's office and asked them to write this letter to clarify their intent. But what we're missing is the intent behind that Board of Pharmacy and just some reassurance about how they, as the enforcing body against these licensees, are going to move forward with any action or lack thereof with respect to the possibilities that I mentioned and Danny Martinez mentioned. Thank you so much for this opportunity to comment. I really appreciate you reconsidering this position.
Thank you, Dr. Hensick.
And seeing no other requests, would you like me to close the panel?
Please do.
It is closed.
Board members, would you have any other further discussion on this issue?
Yeah, Maria. So, hearing some comments. I mean, what is there? I mean, that's what I'm curious myself. Is there anything that we could do? I don't know.
So maybe Eileen or Ann can speak to what the board is legally authorized to do, since this is not really under our jurisdiction. Typically, the board does not educate licensees on issues that are not under the board's jurisdiction. That's something that pharmacy organizations typically take a role in, of educating licensees on issues not under the Board of Pharmacy. But Ann or Eileen, any other comments about what the board can do in light of comments from the public?
This is Ann. So I would say that I would probably recommend that the individuals reach out to the Department of Public Health. We have as well. We were hopeful that perhaps they would be able to come and present today, but that wasn't able to do. I don't think that there's necessarily much for the board to do. Even in the legislation, it really reiterated the role of CDPH in its enforcement. So if you're asking for a staff recommendation, I think that, we continue to monitor the situation. Hopefully CDPH will be releasing information on implementation of the provisions, either through an AFL or some other form of education. We're happy to send out through our subscriber alert system any information that is released by CDPH.
Thank you. So I think that the board does hear the concerns of the public, but at this point, your reference point would be CDPH to answer those specific questions regarding SB 311 in inpatient hospital pharmacies. I'm just giving it a pause here in case any other members of the board have a comment or a question. Hearing none, I think our next agenda item is fairly lengthy, so I suggest that we take a break a little bit early, if that's okay with the board members.
Sounds like a good plan.
Okay, let's resume back at 10:30. Let's give ourselves a little bit of break because the next section will be kind of lengthy. So we'll come back at 10:30.
Sounds good. Thank you, Maria.
Let's take a roll call to assure everyone is back. Jig Patel.
Present.
Thank you. Sung Oh.
Here.
Debbie Veal. We'll pause for a moment here. I'm sure Debbie's coming back any minute. Debbie Veal. Anne and Eileen, do we have a quorum to continue or should we wait another minute?
All right, I'm back.
Oh, thank you. The question is moot. Thank you, Debbie.
Yeah, sorry about that.
No problem. Moving on to agenda item number 7, discussion and consideration of self-assessment forms. Members, each year, in response to changes in pharmacy law, the board must update various self-assessment forms. As you are aware, these forms provide licensees with an opportunity to self-assess for compliance with the provisions of pharmacy law. You may recall that the Communication and Public Education Committee is overseeing the development of an alternative way to complete the self-assessments. I request that we focus our discussion today on the content of the forms themselves and allow the Public Ed Committee to continue its separate work on the process of completing the forms. The draft versions of the updated forms are included in Attachment 5. To formally incorporate changes of the form into law, rulemaking for each form is required. As there are several rulemakings for previous changes to these forms already in process to incorporate changes from prior years, I will be focusing today's discussion on the newly added changes. Our motions included in the meeting materials are also limited to these new changes. You will note that the track changes on the documents include both the new changes in addition to those items previously under review in the rulemaking process. This can be confusing, but please be assured that the track changes you see today contain all the changes from the last approved self-assessment forms. So for today, we'll be talking about the new information, but you will see both new and old information on the forms visible as track changes. I know that can be confusing, and as we go through each of the forms, I can help provide some clarity if needed. So let's get started. Let's start with the compounding self-assessment form. Let's see, I think we're ready to go to the next slide. Is there one after this also? There you go. Thank you. This slide being displayed right now provides the general area of amendment for this form. You will note that the new added changes are identified with underlined text and found in sections 2.13 and 2.14. These changes include the provisions incorporated from the board's sunset bill related to renewal requirements, FDA requirements for compounding for interstate distribution. Members, I believe the changes are appropriate and would welcome your thoughts and would also entertain a motion to recommend approval to the board. This slide displayed and our meeting materials include a possible motion. As noted, I recommend that the motion include delegated authority to me as chair to work with the executive officer to finalize any changes. Members, do you have any questions or comments on the compounding self-assessment and the two areas identified?
I'll be happy to make a motion. Maria is to recommend approval of the proposed amendment to self-assessment form 17M-39 compounding self-assessment and incorporate the proposed amendments into the rulemaking package currently undergoing pre-notice review. Can I just say per displayed on the screen?
Sure.
Yeah, okay. I make a motion per displayed on the screen for compounding self-assessment 17M-39.
Thank you, Sung. Do we have a second?
This is Jig. I'll second it.
Thank you. Any other member comment? Hearing none, I think we're ready for public comment.
This is the moderator. I've opened the Q&A panel. If you'd like to comment on this motion, please click on that Q&A icon, type comment into the text field, and submit that to our panelists. And not seeing any comments, would you like me to close it?
Please do, thank you.
It is closed.
With the motion on the floor and no public comment, I will now take a roll call vote. Jig Patel,
Yes.
Sung Oh,
Yes.
Debbie Veal,
Yes.
and the chair votes yes. Motion passes. Okay, now take a deep breath, everybody. The next 3 self-assessments are currently undergoing rulemaking, so they're in the rulemaking process already, these next 3. As I proposed in the meeting materials, I intend to review each form separately first, followed by a consolidated motion recommending action on all 3. So we'll start with the Community Pharmacy Hospital Outpatient Self-Assessment. Members, displayed in really small writing on the screen, includes a summary of information about the recommended changes. The newly added language is displayed with a wavy line in the attachment. I note that the proposed changes include technical changes as well as changes to incorporate response to changes in regulation and legislation. The slide cross-references the section of the form. I have reviewed and believe the changes are appropriate. Members, do you have any questions or comments just on this one form, the proposed new changes to Community Pharmacy Hospital Outpatient Self-Assessment?
Maria, when I was looking through it, I just came upon something that I think would be clarifying, but probably isn't really critical. It's in 6.8, just to be kind of consistent with 6.6, 6.7. It seems like it should say only the pharmacist who's authorized. So adding the word only just because the other ones above it did. But other than that, I didn't see any issues with the changes.
Thank you. Anne and Eileen, would that minor modification fall into something that the chair and the EO could do after moving forward, or?
And this is on page 12 of 59, 6 point.
For some reason, I found you really quickly.
Oh.
6.8.
Yes, I believe that would be non-substantive and could be delegated to you as the chair to work with staff to finalize.
Okay, thank you, Debbie. Any other comments on the Community Pharmacy Hospital Outpatient Self-Assessment? Thank you. We'll move on to the hospital self-assessment. Again, the summary of newly added changes are displayed on the slide. Get back to my slides here, sorry. There they are. I believe the changes are appropriate and we appreciate any comments from members. Members, any comments on hospital self-assessment form? Okay, hearing none. The next one that we're going to discuss in this group is recommended changes to wholesaler self-assessment. The summary of newly added changes again is displayed on the slide with reference to specific areas of the form. I am comfortable with the proposed changes and would like to hear from members. Having reviewed these 3 forms, I would now entertain a motion to recommend approval if you believe such an action is appropriate. A possible motion is displayed on the slide and included in the meeting materials.
I'd be happy to make the motion.
Thank you, Debbie. Do you have a
Yes.
second? I'm
I
sorry.
can second.
I was gonna say as displayed.
Thank you.
I second Debbie.
Thank you. Okay. Moderator, before we open the lines for public comment, I'd like to make a request. Since we are reviewing 3 separate forms at once here, we will allow for 3 minutes of public comment for the group of forms, these group of 3. I believe that should be sufficient if we limit our comments to the newly added information and not to the previous changes that are still in the rulemaking process. During the continuation of the rulemaking process, the entire form, old and new changes, will be up for discussion during regulatory hearings. I hope that makes sense. For members of the public seeking to make comments, please ensure the record of your comments is clear. Please reference the form and the section of the form as a part of your comments. This would be greatly helpful.
And maybe even the page number?
That would be helpful. Thank you. So with that said, hopefully the instructions are clear. Moderator, we're going to have 3 minutes for each speaker at this part of the public comment, and we're ready for public comment.
All right, we've again opened that Q&A panel. And if you'd like to make a comment, please click on that Q&A icon, type comment into the text field, and submit that to our panelists. Our first comment comes from John Gray. And John, I've sent a request to unmute your microphone.
Thank you very much. Can you hear me?
Yes.
Yes, we can.
Perfect. Thank you. So this is John Gray. I'm a registered pharmacist with Kaiser Permanente. Thank you very much for the opportunity to provide comments on these self-assessments. I'm going to provide comments on the community and the hospital self-assessment, and I'll flag the section and page number when I provide the specific comments. But just by way of background, Business and Professions Code 4427.7 requires that a pharmacy that holds an ADDS license to complete a self-assessment of the pharmacy's compliance with pharmacy law pertaining to the use of the ADDS device pursuant to CCR 1715. Last year's AB 1533 deleted the reference in that section of law to an annual self-assessment. Therefore, in order to make these 2 self-assessments, the community self-assessment and the hospital self-assessment, consistent with current law related to ADDS, I have a couple of changes to recommend. First is on the community self-assessment. It is section 24, or it's question 24.1. It is on page 123 of the publicly available documents of the full PDF.
Okay, just a second.
Looks like page
sorry, John.
32.
That's what I was going to ask you. 72. What was the section number again?
Sorry, 32 of the community, and it is section number 24.1.
Okay, pause for a moment. Thank you.
And this is the moderator. I'm pausing the timer when we're waiting for our members to get there.
Since it is, these
Appreciate
are long
that.
forms.
Thank you.
Go ahead, Dr. Gray.
Thank you. So my recommendation on this one would be for the text of 24.1 to say, does the pharmacy hold an automated drug delivery system license? If yes, complete the self-assessment for automated drug delivery systems pursuant to CCR 1715. And then I'm ready to give my comment on the hospital if the chair is ready. It's very similar.
Could you just repeat that again, Dr. Gray?
Yeah, of course. So what I would recommend would be for it to sit for 24.1 to say, does the pharmacy hold an automated drug delivery system license? If yes, complete the self-assessment for automated drug delivery systems pursuant to CCR 1715.
Okay, go on. I think we're going to discuss that probably. Next.
Okay, and then the hospital one, my suggestion on the hospital one is very similar. It is on page 211 of the public document, and it's page 31 of the hospital self-assessment, and it is question number 29.3. Let me know when you're ready for me.
Okay.
Okay. My only suggestion here would be for 29.3 to begin by saying, if the pharmacy holds an automated drug delivery system license, the pharmacist in charge has completed the self-assessment for automated drug delivery systems pursuant to CCR 1715. And then the rest would, I would suggest, would remain the same.
Okay, and your next one?
That's actually it on these three forms.
Okay.
So thank you very much for the opportunity to provide comment on these.
Thank you. Anne and Eileen, would it be appropriate to have discussion on his specific comments now, or should we wait for all of public comment and address them all at once?
I think it's better if we have public comment all at once and then discuss the different comments.
Okay, thank you, Eileen.
And that is our only comment request received thus far.
So I guess that's the question that's moot also. We'll wait for another moment here and see if anybody else comes on. Okay, I think we're ready to close public comment on these three forms.
All right, it is closed.
So the first, I think we need to discuss each of those individually to see whether we do change our motion. The first part is on hospital and, community pharmacy and hospital 24.1.
You know, one of the questions I have is about the CCR reference, because in our document it says 1713 and he said 1715, which was also the reference when in the hospital one. So, Eileen, can you clarify if that reference is correct for community at 1713 versus 1715?
Sorry, Debbie, I'm still trying to find the page.
He actually gave it. If you're in the chair report, it's page 123. And then you go to near the bottom where it says automated drug delivery systems, which is page 3259 of that document. And it's the very first item, 24.1.
I think it is 1715.
So this makes things a little challenging because both areas, maybe it's an interpretation. Because if you remember the regulations on ADDSs, it requires a self-assessment for all. Whether you're licensed or unlicensed, a self-assessment must be performed, but it's performed and reported differently based on whether you're a licensed ADDS or a exempt from licensure ADDS. So I think that's where the challenge is in the wording. Anne or any other member of staff that worked on this, maybe we'll just take them one at a time, looking at the community hospital outpatient. This is the one that is, from what I understand, this is an area where there are no exceptions, that all ADDSs are required to be licensed.
Hi, Maria, this is Anne. I would agree. Sorry, Eileen, if I jumped in before you. I agree that for community pharmacy operating in ads, I am not aware of a licensure exemption.
Right. So, so if that makes things more clear for the board members, the reason it doesn't mention licensure here is because all of these in this area of practice require licensure and they require an annual self-assessment. So if you have an ADDS, you're required to do the self-assessment form, and that's all that's been stated in 24.1. But there's a question about the CCR. Maybe we could take that offline to assure that the CCR is correct. Is that okay, Anne and Eileen, to include with any corrections that we have after the vote?
Yes,
I think I believe that would be.
I think those are clerical, non-substantive.
Yeah, okay. Board members, any other questions about 24.1 before we move on to the hospital assessment question?
Well, I thank you very much, Maria, for pointing that out, but then that makes me feel like I think we use these documents also to educate. So do we need to say something here like since all pharmacies who use an automated drug delivery system must be licensed, something to that effect, just to kind of make the statement and assure that, I guess it's just a reminder, because I think that is part of the self-assessment, but I don't know, maybe that makes it too messy.
I think it's an interesting point, but it does go way into the weeds on the ADDS self-assessment about when licensure is needed and when licensure is not needed, because everyone has to fill out the self-assessment. They should be getting those questions there, if that makes sense.
Okay.
Anne or anyone else want to add to the discussion on 24.1? Let's move on to the hospital self-assessment. I think that's the one that is probably a little more challenging, 29.3.
Yeah, and as he said in the document, it's page 211, or in the chair report, it's page 211, or in the document, it's page 31.
9.3. So this, I really didn't, and maybe others heard it differently. I don't see a change needed here because annual self-assessments are required by all, licensed and unlicensed. It's just the process that's different for a licensed ADDS versus an unlicensed ADDS. They also fill out the self-assessment and they just have a separate way of processing that form. Anne or Eileen, am I missing something from the public comment or from the wording that's here that we should consider?
I am still trying to review Dr. Serpa, but from what I've seen, I don't think so, but I'm still trying to find the exact.
We'll give everyone a moment. I know there's a lot of pages here. So this is page, like Debbie said, thank you, Debbie, 211 in the chair report. And if you have a printed copy, it's page 31 of 41 of hospital self-assessment form. And we're looking at automated drug delivery systems. And the specific public comment was on 29.3. So I felt comfortable with it as worded, since it's required by all. It's not if you have a license, do this, and if you have a license, do that. If you don't have a license, do that. All are required to fill out an annual self-assessment.
I might suggest, if it's agreeable, that the committee be, direct the chair to work with staff to confirm. We're going to be confirming the reference on the other section as well, and we can just confirm that the language is consistent with the law.
How does the board members feel about that?
I think that's great.
Yeah, I agree. This is Jake.
Yep.
Okay. And just for process, since we have a motion, it sounds like our motion is not changed, but we've had additional member discussion. I don't see that we need to reopen public comment. Eileen, can you confirm that we are okay to move forward?
That's correct. If you're not changing the motion, then there's no need to open it up.
Thank you for confirming. Okay. So we have a motion on the floor and public comment received. I will now take a roll call vote on the 3 self-assessments forms. Jig Patel.
Yes.
Sung Oh.
Yes.
Debbie Veal.
Yes.
And the chair votes yes. Motion passes. Thank you. Change screens here. The last self-assessment form for our review is automated drug delivery systems. New language is reflected with double underline. Again, the slide on display summarizes the changes, primarily including technical updates, changes to incorporate changes in regulation and statute. I had suggested that we more clearly highlight the requirement for licensure. As you can see in our previous discussions, this is an area of confusion in many. So I had suggested a minor change in section 2.9 that is included in your document, and you will see it in the document, the draft self-assessment form, as a note to 2.9. But other than that addition, I agree with all the changes offered and would welcome member comments on the changes. Hope I didn't make that more confusing, but members, any comments?
2.9.
So in 2.9, it's included in our draft, was a comment that I made to staff, and they incorporated that.
So or maybe, wait a minute, maybe I'm looking at this. This is 17 point what? I think I'm looking at the wrong one.
249, page number 249, Debbie.
Thank you.
And 4 of
I was on the wrong
44.
one. I was on 229. Okay.
Sorry, 249.
Got it.
I had the wrong
And
format.
so you, licensure operating these provisions require, please refer, okay. That's the note that you're talking about that you added, right, Maria?
Yes.
The sentence at the 2 sentences at the bottom.
Yes. So that was coming from me. The rest of it came from staff because this is an area of confusion. So I thought that would provide some clarity.
Let's see. Do we need to make, and I'm just kind of flipping through, I can't, you know this document probably better than I. What about just a regular pharmacy, like in the community? Because we were thinking that, do we need to make a note? Because 2.9 is about AUDS located in an emergency room. Does that cover the other question that was on?
I'm hoping that section 2 does cover that question about the different practice settings, that walks people through the different practice settings.
I'm just wondering if we want to make, I'm not sure. You're the same comment that you kind of made, that, you know, that it's specifically under. Okay, so your note really applies to everything. It's just at the end of section 2.
Correct.
What would you think if you put that note up at the beginning of section 2? Because then,
can I clarify for just a moment?
Yeah, go ahead, Anne. Yeah, I think that's confusing.
So
Anne, go ahead.
Yeah, I think that what Maria is referring to in terms of clarification is the use of the ad specifically in the ER. Maria, I apologize if I am misunderstanding. And that is specific to 2.9, Debbie. That's the provision for the use of the ads in the ER. And I think that that's where Maria was recommending some clarification about that licensure piece. So not quite sure that would be appropriate at the top of the section, but we could absolutely put in some additional clarification about licensure requirements or something if that's what we're seeking.
So Debbie, if you look at page 2, where it says reasons for completing the self-assessment, that walks people through the different practice locations and information about when it's applicable to them and when it's not. Anne is correct. I probably did not state it correctly enough. You know, there is confusion already about where ADDSs are required to be licensed and where the license is exempt. And specifically, licensure is required in an emergency room, even though it's in an inpatient hospital, if that emergency room is providing outpatient prescriptions via their ADDS. And so that's what that note is about. It's very, very, very limited to that one provision. So your question is more of when do people know when they need to be licensed, or when did they know
My
that they need?
question goes back to Dr. Gray's comment on, it was, board packet page 123. It was community pharmacy, item 24.1. And so this is document 17M-13. And the comment was made that we don't need to say, if you're licensed, because they all have to be licensed. And so just like I think we cleaned up the hospital comment from page 211 in the board packet, I just want to make sure that we have cleaned up also his comment from board packet page 123 in what we're doing here. So let's see, 123 was in regards to automated drug delivery systems in a community pharmacy. I think you said that they all had to be licensed. So 249. We just, I think that's great what you added for the AUDS as the emergency room. I just want to make sure, since it's covering that one comment. I just want to make sure that we're, once again, this is a little bit educational for people filling this out, and that's the whole reason we've made these so robust. So I don't know, is there anything else we need to do to make sure that it's clear? In other settings, it has to be licensed. And I'm fine if you want to.
So look under 3.1 and see, does that cover it?
Okay. Go in there, 3.1. And is licensed by the board, okay.
And 3.3.
Yep, that does.
I'm thinking that.
I think that's good. Okay, that's what I was seeking. Thank you.
Okay, good. Thank you. That's a good question. Members, any other further discussion or an opportunity for a motion?
We have a motion, possible motion. I can make that possible motion as stated as displayed in the screen.
Thank you. Do you have a second?
Delivery system 17M-112.
I can second Debbie's motion.
Thank you. And moderator, I think with that, we are ready for public comment. And we're going back to 2 minutes of public comment since we're looking at a single self-assessment form.
Okay, we've again opened that Q&A. If you'd like to comment on this, please click on that Q&A icon, type comment into the text field, and submit that to our panelists. First comment comes from John Gray. John, I've sent a request to unmute your microphone.
Hello again. Just want to provide comment on this ADDS self-assessment. It is similar in nature to the comments that I provided on the community and hospital self-assessment. This is question 3.24 of the ADDS self-assessment on page 252 of the public packet. It's page 7 of the ADDS self-assessment. So I'm assuming you all are there, so please stop me if you want me to hold on a second. So the text, sorry?
I said, got it. You're
oh, cool. So the text of the statute in Business and Professions Code 4427.7 gives the self-assessment requirement related to ADDSs, and it states in part, a pharmacy holding an ADDS license shall complete the self-assessment performed pursuant to section 1715 of Title 16 of the California Code of Regulations. So my suggestion on 3.24 of the ADDS self-assessment is that the question should read, the pharmacist in charge of each licensed ADDS assesses the system's compliance with current laws and regulations. And then under bullet number 1, instead of stating annually before July 1st of every year, should state before July 1st of every odd numbered year, because last year's AB 1533 deleted the reference to an annual self-assessment that was previously within 4427.7, in theory, to harmonize it with the every other year self-assessment for every other self-assessment that licensees do. I also do want to clarify my previous comment. I hope you'll permit me, just so you know where I'm coming from, and that is that the definition of the term ADDS in BPC section 4017.3 is very broad, and it includes AUDS devices, APDS devices, and those devices that could be considered one of those that are housed within the four walls of the pharmacy.
15
and
seconds.
BPC 4427.2J exempts from licensure ADDS devices that are within the licensed premises. So if a community pharmacy has an ADDS that's in the licensed premises, that does not need to be licensed. And that's my concern about the community self-assessment. Many thanks.
Not seeing any other requests for comment. Would you like me to close the panel?
Yes.
It is closed.
So I think we do have a couple of points of clarification here. Besides the last comment that Dr. Gray made that is on a different topic, I need to think about how we're going to go and address that in some way. But looking specifically at 3.24, again, I'm repeating that all ADDSs require a self-assessment form, licensed and unlicensed. So I think each licensed ADDS comment is not sufficient or not applicable here, because every ADDS requires a self-assessment, whether they're licensed or not. But his comment about the language changing from every year to every other year, Eileen or Anne, are you familiar with what Dr. Gray is referring to has been a regulatory or licensure change or legislative change on that?
I'm trying to look at those statutes because I don't recall that. I'm not saying it did not happen.
I was under the impression that annual was what was in all of our discussions over this last year and on our FAQs. And, you know, we've had lots of ADDS discussions, and it was always about annual.
So whether licensed or not licensed, everybody that has ADDS must complete it every year.
Yes. Well, the every year part is the part that we're figuring out, because according to Dr. Gray, that part was removed somewhere. But they do have to fill out a self-assessment, whether you're licensed or not. The process of submission of the information and where the information goes is different for those licensed ADDSs and the unlicensed ADDSs.
Thank you.
So while Eileen's looking that up, I have a question for process. Dr. Gray added some comments based on the previous agenda item. Are those not up for discussion anymore because that agenda item is closed? And we could suggest that he bring that up during regulatory hearings. So process question on the item that was discussed in public comment that was not this agenda item.
The process question would be the board adopted the motion as passed. So if it wanted to go back, it would have to rescind the motion and redo another one, or we can also take it up when the rulemakings are also issued or at the board. That would be the committee's preference. But because you've already voted on a motion, you would want to go to rescind the motion and reopen it if you want to consider them again.
So I know I have a preference, but board members, do you have a preference on the point of order on the previous agenda item, to reopen it or to discuss it during regulatory hearings? We're going to have several regulatory hearings coming up.
I like to present things as clean as possible, so I'm going to vote to turn down and then fix this and then revote.
Or can we just rescind the motion? Or,
That's
Yeah,
what
we
Debbie's
could,
saying.
because I was the first, you were the second, we could rescind the motion, right, Sam? Can we withdraw our motion, Eileen? Or would you rather us vote it down?
So to clarify, are you talking about the motion specific to the community pharmacy? Because I do believe that there was a vote on that. So I don't know that you can rescind the motion on action that you've voted on.
Because there was a vote, the committee would have to vote it down to retake it up again, not just rescind the motion.
so we have to make a motion to undo the motion first?
Right, and see if the committee votes in favor of that and then take it back up.
Well, and since we have a motion on the table, though, don't we have to take care of the motion on the table?
Yes, let's finish this
Yes,
section.
so
Let's finish
Let's
this
first
one.
deal with this one.
So the ADD, I was just trying to give Eileen some time to look up the every odd year versus every year. My understanding is that ADDS self-assessment was still annual. That seems
If
to be
I
your
might make a
big point.
suggestion as part of the motion, perhaps through the delegation, we can confirm both the frequency of the self-assessment as well as the provision for the requirement. We can confirm with council. It's not a policy issue. It's just restating the law. So we can confirm the state of the law with council and work with the committee chair consistent with the proposed motion.
So do we need to add anything to the proposed motion? To do that?
Authorize the executive officer and chair probably would be the only thing. So who placed
Yes, my
the motion?
recommendation would be to my recommendation would be to add in the chair where it's further authorized to the executive. I would recommend that. It's in there. It's actually authorize the chair and the executive officer to further refine the language consistent with the policy discussion. So I think it's in there already.
Great,
I
thank
agree.
you. So we have a motion on the table. The motion has not changed following public comment and has not changed following additional board comments. Board members, do you feel comfortable that we can move along with the vote for that?
Yes. But I'm looking at this motion on the screen. Where does it say executive officer and chair? Making process.
It's the second sentence.
Authorize. Okay, there we go. Okay.
Thank you, Debbie. Okay. So again, we are looking at the self-assessment form for ADDSs. Motion is on the floor. Public comment has been received. I will now take a roll call vote. Jig Patel.
Yes.
Sung Oh.
Yes.
Debbie Veal.
Yes.
And chair votes yes. Motion passes. Members, I'm going to take a pause here for someone to make a motion. Can we make a motion? I guess it's on the previous agenda item.
So
I guess I believe that there's already been delegated authority for the chair to work with the executive officer to further refine. And if we are looking at it from a legal perspective to confirm that the self-assessment is appropriately referencing the law, I'm not quite sure again that there's that it goes beyond the delegated authority of the motion, but I'll defer to council.
Yeah, and it doesn't, so we've already got that in the motion as we did with all these forms. So unless the person who was talking about withdrawing the motion wants to make a specific thing that would be outside of what the chair would discuss with the executive officer in finalizing these, then I don't know whether that would be necessary or not to redo that.
So Debbie, I think it was you and potentially Sung who we were talking about process. And it sounds like according to Eileen and Ann, the motion that was approved allows for that discussion to continue. And we don't need to undo the motion and look at the forms at this point. It's under the authority of the chair and the executive officer. Is that okay with the board members?
Yep, I agree with, I heard it the same as you and I agree. So I don't think we need to make a change, but I think this motion was actually sung, so.
I'm okay with it.
Okay, so everyone is okay with the motions and the work going forward based on our previous votes, correct?
Yes.
Yes.
Okay. Okay, take a deep breath. We finished a lot of work today. So let's go on to the next item, which is the attachment 6, includes the enforcement statistics for the first 6 months of the fiscal year. Very, very interesting information. I would draw the public's attention to the numbers there. Then you could actually see the quantity and the distribution of the different events for citation, fine, discipline, etc. The distribution information is very interesting. Members, do you have any questions or comments? Okay, let's open for public comment.
This is the moderator. We've again opened the Q&A panel. If you'd like to comment on this item, click on that Q&A icon, type comment into the text field, and submit that to our panelists.
Seeing none, I think we can close public comment.
Will do. It is closed.
That was for informational purposes only. So before we adjourn today, I'd like to thank everyone for your time and participation. The process went very smoothly for some very difficult agenda items, and so I appreciate board members and members of the public that assisted us in having a fruitful discussion in a timely manner. Our next meeting is scheduled for April 20th. And since we are a little bit ahead of schedule, I understand the next board meeting is later in the afternoon, so we have quite a bit of a break here. I appreciate everyone's attendance and attention. Thank you.
Thank you, Maria. Thanks, everyone.
Thank you, everyone.
Thanks, Maria.